In order to understand what's going on here, it's important to know what the point of a Chapter 13 is. Unlike Chapter 7, where we just erase debts, Chapter 13 uses future income to pay all or maybe just a portion of the debt through a court-administered Chapter 13 plan. The plan has to satisfy three main requirements. There are others, but three main requirements. And if you can propound a plan that satisfies these three requirements, then the judge assigned to the case will confirm the plan. While you're in your Chapter 13, you make a monthly payment to a Chapter 13 trustee that is appointed by the court to your case. The trustee then takes the payment, distributes it to your creditors according to the terms of the judge-confirmed plan. In the meantime, you don't deal with the creditors at all. And then at the conclusion of the plan, any debts that weren't paid in full are typically discharged. There are a couple of exceptions that we'll discuss in just a little bit. So, what are these three requirements? Well, there's no preferred order in which to cover them, so I'm just going to sort of pick them at random. Requirement number one, it's sometimes referred to as the best interests of creditors requirement. It's sometimes referred to as the Chapter 7 liquidation for Chapter 13 requirement. What it says is, over the life of the plan, which is typically 60 months if you're above the median income, and 36 months if you're below the median, though that can be stretched out if you wish, but not any longer than 60 months. Over the plan, you have to pay back your creditors at least as much as they would have gotten if you'd done a Chapter 7. Now, this requirement is usually a source of some confusion because people will say, wait a minute, I thought the Chapter 7 creditors don't get anything at all. And that is true of the typical Chapter 7. But sometimes creditors do get paid in a Chapter 7. How? Well, in a Chapter 7, because debts just go away without you paying anything at all, there are some limitations. One of those limitations is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in a Chapter 7. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own. And I mean literally everything down to the shoes on your feet. And all of your possessions get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed by the court to your case to seize and liquidate and have money to pay your creditors. We determine whether something's exempt or non-exempt by appealing to one of two exemption tables. One table is for homeowners with equity, the other's for everybody else. Now, what I'm saying is peculiar to California. Some states use a federal exemption table, some just have one state table. In California, we have two state tables, and we don't use the federal table at all. In any event, each table has a list of various categories of possessions. In a Chapter 7, as we list our stuff, we stick it into these categories so that it's protected from the depredations of the Chapter 7 trustee appointed by the court to your case. In a Chapter 13, because you're going to be making payments to your creditors through the Chapter 13 plan, you get to keep everything. No trustee is going to take any of your possessions. But we still go through the exercise of listing everything that you own, dividing it into exempt and non-exempt categories, because whatever the dollar value is of the non-exempt assets is the minimum that you can get away with repaying your creditors over that Chapter 13 plan, unless the value of the non-exempt assets exceeds your total debt. You never have to pay back more than 100% in a Chapter 13, plus the interest stops accumulating, so it's not a moving target. So, whatever the creditors would have gotten in a Chapter 7, that's the minimum you can get away with repaying them in a Chapter 13, and that's measured by the dollar value of your non-exempt assets. So that's the first of these three main requirements in a Chapter 13. The second requirement is that the plan must be fair. And if there ever was a vague term, that's it. Generally, fair has very little meaning other than to describe the place where you get cotton candy. But in this case, we can make it extremely precise. There are two possibilities. Number one, you propose a 100% plan, meaning that over the life of the plan, you're going to pay your creditors 100% of what you owe them. Remember, no interest accumulation, which is why you can pay them off in 5 years as opposed to 32 and a half years if you're making payments on credit cards. So that's our first possibility. You have a 100% plan. 100% plans are by definition fair. But most plans are not 100% plans. So if you're going to propound a less than 100% plan, then each month for the life of the plan, you have to devote your disposable monthly income to the plan. So what is disposable monthly income? The Bankruptcy Code does have a technical definition of it. What I'd like to do is strip away the technicalities and just get to the core idea. What we do is we take your gross income. Ooh, that's gross. Well, bad joke there. Gross income meaning before taxes, before Social Security, before living expenses of any kind whatsoever. From that, we subtract out what you're paying in taxes and Social Security, and we subtract your reasonable living expenses. Now, it has to be reasonable living expenses. If you're going to claim that you have a strict diet of king crab and prime rib, you might find that the judge won't go along with that unless you have a 100% plan, in which case you can eat that stuff to your heart's content. In any event, disposable monthly income is what you have left over after you've covered your taxes and Social Security and you've covered your reasonable living expenses. So it already has embedded in it the idea that, yes, you've got to have food, clothing, a place to sleep, utilities, transportation. And no, it's not going to be, well, all you have is one hot meal a day and it's just a bowl of steam. No, it's reasonable. But what's left over is what you devote to your plan payments. So that's disposable monthly income. So to summarize this second requirement, the plan is fair if either it's a 100% plan or it's a plan in which you devote all of your disposable monthly income to the plan. The third requirement is a little harder to nail down. So I'm going to give you an unsatisfactory definition of the term that's used to describe it, and then we're going to take a look at an example to sort of flesh it out. The plan has to be feasible. For a plan to be feasible, you have to have enough disposable monthly income to, number one, satisfy that Chapter 7 liquidation requirement, number two, satisfy the fairness requirement, and number three, to treat certain special creditors the way they're entitled to be treated. Awfully vague, not very satisfying. So here's my quintessential example. And to understand my example, let me make a comment here. In the taxonomy of debt, there are different ways to break things down. One way is to distinguish between what are called secured debts and unsecured debts. A secured debt is a debt that's secured by a tangible asset. You don't make the payments, the creditor can take the asset back. So there's collateral or security for the debt. Those debts are not treated the same way as unsecured debts in bankruptcy because the creditor does have special rights attached to the collateral. Unsecured debts are debts where there isn't something that can be repossessed if you default. Typical examples are things like credit card debt, student loans, medical debt. I mean, you have a heart transplant, they're going to repossess your heart? Of course not. They might take a kidney, though. Anyway, so what we've got there is unsecured debt. You go with your MasterCard, you buy the TV, and you don't make the payment. Citibank cannot come and repossess the TV. Now, they can sue you. They can get a judgment against you, use that to garnish wages, seize money out of bank accounts, but they can't repossess the TV because that's an unsecured debt. So In the realm of unsecured debts, some debts are not dischargeable. You're probably already aware of the fact that student loans are typically not dischargeable. Another kind of non-dischargeable debt is tax debt, most tax debt. But there's a special breakdown in unsecured debts between what Congress has labeled as priority unsecured debts and non-priority unsecured debts. So Congress, in its extremely finite wisdom, has seen fit to give better treatment to priority unsecured debts. Student loans, by the way, are not priority debts. They're not dischargeable, but they're not priority debts. One type of non-priority debt is most income tax debt. There are some income tax debts that are dischargeable and are non-priority. But if you have a priority tax debt, it must be paid in full over the life of the Chapter 13, even if the other creditors get chump change. So here's my example. Let's say, for argument's sake, you have $35,000 worth of priority tax debt. And we go through the analysis, and it looks like you have $10,000 worth of non-exempt assets, and you've got disposable income of $500 a month. So we propose a plan that's going to pay $500 a month for 60 months. Bingo, we certainly satisfy that Chapter 7 liquidation requirement. Are we home free? No. Why not? Well, let's see. We have 60 months. That's the maximum length of a Chapter 13 plan. Times 500 is 30,000. But wait a minute, by hypothesis, we said you had $35,000 worth of priority tax debt. So there's an example of a plan that is infeasible. So that's what I mean by you have to have enough income to support the plan that satisfies those requirements. There are other kinds of debts involved, but I think that one is maybe the best one as an example. Now, I should say that if you have a student debt, which is non-dischargeable, and you don't pay it 100% through the plan, you'll certainly get credit for the amount of student debt you paid through the plan, but the unpaid portion you will still owe at the completion of the Chapter 13 case. There is one final thing that may be idiosyncratic to the Central District of California. We do not, for the most part, have what are called conduit payments through a Chapter 13 plan. So you may remember I mentioned secured debts. Typically in a Chapter 13, our focus is on unsecured debts being paid through the plan. If you have an ongoing secured debt, then you make those payments directly to the creditor. So if you have a car loan, you just keep on making those payments just like clockwork. All the other debts can go into the Chapter 13. If you have an arrearage, that is, you're behind on your car payments or maybe your mortgage payments, that is a pre-petition liability that goes into the plan. So what do I mean by pre-petition? The day we file your bankruptcy petition is the petition day. Everything prior to that is pre-petition. Everything after that is post-petition. So the pre-petition arrearage goes into the plan. The non-arrearage portion, you just keep making those payments directly to the creditor. A conduit payment is when the secured debt payments on an ongoing basis are paid through the plan. Some parts of the country require that Chapter 13 plans have conduit payments. In the Central District of California, we don't have that as a requirement unless there are additional facts that warrant the Chapter 13 trustee asking the bankruptcy judge assigned to your case to require conduit payments. So that does, I suppose, on one level, simplify things because the trustee does get a payment for doing the administrative work of accepting the payments and distributing them to the creditors. And since the trustee gets that, that effectively increases the amount of that secured debt payment if it's being done as a conduit payment. So ideally, we like to have a case where there are not conduit payments. But if you've had a spotty history, then the Chapter 13 trustee may say, well, look, Your Honor, it doesn't look like this debtor really can be trusted to make the payments directly. We'd like them to be conduit payments. So that is in the realm of pre-bankruptcy planning, where we like to take a look at your history and see if there are going to be any problems associated with that will require conduit payments. Now, there are other requirements in the Chapter 13, but those are really the make or break ones. There is, of course, the standard requirement for all individual debtors in either a 7 or a 13 that you have to take the pre-bankruptcy course, and you have to take the post-petition course, and you'll get certificates that the first one has to be filed with the petition. The second one has to be filed in a timely fashion after we file the petition. In Chapter 11, in an individual case, while the code does say you do have to take the pre-petition course for reasons that may just be that Congress let it slip through the cracks, there isn't that post-petition requirement of that course. Chapter 11 for an individual tends to be like Chapter 13 on steroids. It's a much more complicated chapter. In any event, to summarize, you got those 3 main requirements: the Chapter 7 liquidation requirement, the fairness requirement, the feasibility requirement. And if you can satisfy those requirements, the judge will confirm the plan, and then you are protected. And a lot of folks succeed in Chapter 13. They may end up paying a relatively small percentage of their total debt, and they enter into the land of debt freedom after their plan, having no more debt other than perhaps a home mortgage.